Hello everyone, welcome to my class. Today I'll be talking about Consumer Protection Act 2019, and the specific topic which I am taking under this act is related to mediation mechanism. Talking about the mediation, it is very economic and also to reduce the case backlog from the Consumer Commission, this process has been inculcated by the Act of 2019. The very important thing which I would like to tell you in foreign countries like US, UK, Europe, the ADR mechanism is already being followed. So, what the parties do instead of approaching the courts, they first approach the mediators who decide the case. Like in America, 75% of the cases are decided with the help of mediators. We all know that the Consumer Protection Act 1986 has been repealed by the Consumer Protection Act 2019 due to many reasons. The Act of 1986 did not contain those provisions which are very necessary, keeping in point of view the present scenario. The commendable step which is taken in the Act of 2019 is the introduction of the concept of mediation. Consumer is a very vital part of any economy. It is because of him the economy is growing. So if a consumer is satisfied in all the respect, it leads to development of a nation. Consumer has got several rights. He has right to be protected against the hazardous goods and services. He has every right to protect his life against those goods, against those services which are threatening to his life. The second right is he has every right to be informed. He has right to know about the potency, about the purity of a good. The product which he is taking, the services which he is availing are pure or not, are potent or not. This has to be in the knowledge of a customer. Likewise, a consumer has right to choice. Choice means to choose from amongst the different options available to him. Nobody can compel him or force him to purchase the product or to avail the services from any particular shop, from any particular service provided. It is the consumer only who will choose for himself. There cannot be any type of pressure upon him. Another right is right to be heard. Means if he has any complaint regarding any good or regarding any services, then where he will lodge that complaint. In that case, he has every right to be heard. He has every right to put his complaint before the competent authority. He has every right to seek redressal for his grievances. And the last right is he has right to know, he has right to awareness regarding the laws, regarding the rights, regarding the duties. So these were some of the rights which were granted by the Act of 1986, and the same has been inculcated in the Act of 2019. Now, the very important provision which we will deal in today's class is mediation. We all know that whenever a consumer has a complaint, he has a right to remedy. And in that remedy, he has a right to access courts. So, courts in the form of forums or commissions. We had three-tier commissions which were provided in the earlier act, which is district forum, the state commission, and the national commission. These three-tier forums taken as it is from the old act and been inculcated under the new act also. But we all know that these commissions are already very much loaded with the pending cases. Their procedure is quite technical and it involves a lot of complications. As a result, the consumer was not getting the justice in time. So, what the government did, the government put the mechanism of mediation under the Act of 2019. Under this mechanism, what consumer will do, instead of approaching the courts, he can approach a mediator. Then the mediator shall facilitate the disputant parties with a solution. Here, the important point which is to remember is that the mediator is not a judge. he will not involve in any procedural formalities. He will have to facilitate both the parties in reaching to an agreement, in reaching to a decision. So, the role of a mediator is quite different from the judge who sits in the civil courts or who sits in the consumer commissions. So, here it is an additional option provided under the Act. So, who will mediate? A mediator will mediate, and the mediation cell shall be attached to the concerned commission, like a district commission shall have its own mediation cell, state commission shall have its own mediation cell, and likewise national commission shall also have its own mediation cell. So whenever a consumer is having a complaint, he will approach the commission, and if the commission thinks that there is an element of settlement that can exist between the parties, he will refer such dispute to the mediation cell, where the mediators will mediate the dispute. And at last, a report shall be filed by the mediator that yes, the agreement has been reached between the parties, and such agreement shall be forwarded to the concerned commission. And in case the parties do not agree to the mediation process, or the parties are not satisfied with the mediation process, then in such case the mediator will again write a report that the mediation process has gone unsuccessful, and in that case the mediator will again refer the case to the concerned commission from whom the case was referred. So this is this very simple process which has been introduced under the mediation mechanism in the Act. However, there are very various things which are needed to be inculcated, keeping in view the international best practices. So it is very necessary that in India also we can adopt this practice, and it will be helpful in reducing the case backlogs as well as providing the speedier justice to the consumers. So that's it for today's class. See you in the next class with a new topic. Till then, keep learning and keep smiling. Thank you so much.